నువ్వు అక్కడ పెట్టు, పక్కన పెట్టు. అక్కడ కూర్చొని మాట్లాడతావా? పక్కన పెట్టు, నేను తర్వాత మేనేజ్ చేస్తాను.
Right, good evening to all of the participants. We will start this session now, and we shall, while we wait for the others to join, I will briefly run through what topics we are going to cover in this session. In this session, we are going to cover something called general exceptions. We will start with BNS, the act that has replaced IPC, and we will start with general exceptions, the chapter number 3 of BNS, ranging from sections 14 to 44. We will try and understand the meaning of general exceptions and why it has been put there, and we will try and understand what the need for the general exceptions to exist, and we shall also try and understand the concepts behind some of the general exceptions and the actual general exceptions and the actual sections we will try and run through very briefly, and we will try to decipher the legal parlance of the sections, because oftentimes these sections that are written not simply and not in a legible way, to put it roughly. They are that is because the intention behind writing the section is not for people to easily understand it. The intention behind writing the section that way is to limit the loopholes. There is a lot of people that might try and use technicalities to get out of wiggle out of certain situations that are mandated by the section, to try and avoid that. The sections are written in a certain way that is called legal parlance. We will try and decipher the legal parlance, and I have tried my best to extract whatever useful information I could extract and simplify that piece of information, so that the participants will have an easier time trying to understand the section, and once the concept behind the section is understood, then
Excuse me.
it will become easier to do a self study. And once the participants are aware of the etymology behind the certain words that are used in the section, and once the participants understand the concepts behind the section, certain Latin phrases, certain history behind the Latin phrases, why they have come up with such phrases and why it is practiced, all of this information will give you an extra edge when you sit down and try and read the act for yourself. So I will try to provide that background that is necessary for it becoming easier for the participants to read the act on their own. Now, general exceptions. There is a lot of acts, or there is a lot of things that people can do that can be termed as crime. But then, because largely whenever they do certain acts, they kind of check all of the essentials of a crime, but then there are certain things that might have to be taken into consideration, and after taking those things into consideration, the people who have done those things might be excused. These are the things that have been put in general exceptions. Maybe if a certain somebody has done something, maybe he has done it out of coercion, maybe he has done it because he did not really understand what he was doing, maybe he did not have any choice, maybe he did not intend for that thing to happen the way it did. All of these things, if they are prosecuted, it not only damages the reputation or the life of the person who has done the said act, it might also remove certain depth from the act itself, from the law itself. In order for it to be prevented, the general exceptions have been put in place. Essentially, what makes up the general exceptions is certain things, if they happen in a certain way, and if there is certain loopholes, officially granted loopholes this time, if a certain act falls under one of these loopholes, then that person can be excused from the act that person did. Now, some of these loopholes officially are: number one, mistake of fact. Mistake of fact and mistake of law, these are two things in legal parlance that need to be understood first. A mistake essentially is an incorrect understanding or a belief about a fact or a law at the time of committing an action. An incorrect understanding, that is a mistake. Essentially, in this context, we are talking about mistake. There is two kinds of mistakes of fact, mistakes of law. When a party is mistaken about a key fact relating to any action, that can be termed as mistake of fact. When a party is mistaken about the legal implications of their actions, then it is called a mistake of law. Now, what is the apart from the perfunctory difference between the two, there exists another difference that I shall discuss in due time in this session. Whether or not the mistake or the ignorance of law, because for there to be an incorrect understanding, there has to be some level of ignorance. Now, is that ignorance forgivable, and in what context is that ignorance forgivable, we will get into at a later point of time. So, number one is mistake of fact, number two is judicial act. Mostly when a judge acts in a certain way, he is in charge or he is given responsibility to punish people who have violated the law. But what even a judge in this concept, in this law, in generally in legal parlance, even a judge, doesn't matter how learned he is, doesn't matter how educated or knowledgeable he is still human, and to err is human. Therefore, there are certain checks and balances that have been kept in place to make room for the error of the judge, and this is one of the in general exceptions that room exists, that room of error. And how, in what manner have they defined that room of error is what judicial acts encompasses. Number 3 is accident, something that might happen that we did not intend for to happen, and despite our best efforts, or despite us not thinking that would happen, sometimes accidents happen, and that is number 3. Number 4, necessity. One might not have had a choice with regards to certain acts or with regards to certain circumstances. That is necessity. The next one is infancy. Infancy meaning not just of the body but of the mind as well, which comes to insanity. Infancy meaning there are certain age appropriate things that are written in the act, meaning at a certain, only crossing a certain age, only after crossing a certain age, an individual might develop the mental capacity to understand the hows and the whys and the implications of his actions, and whether or not to do certain things, whether or not he will be punished for certain things. Is something right, is something wrong, what should be the timing of something, is something supposed to be done in front of people, or is something supposed to be done in private. All of these things one would learn as one ages. If the age is not there, the understanding is also not there. Therefore, infancy is another general exception. Insanity, once again, is a general exception. Despite having the age, one might not have sometimes the mental capacity, which might be the reason of some past trauma, or which might be a genetic condition, or which might be something else entirely, which would act as a handicap with respect to a certain someone being able to understand the repercussions of his actions. Therefore, insanity. Intoxication, there is one more thing that might get ingested, or that might get drunk, that might get eaten, that would impair one's reason. And while he is high, while he is under the influence of that substance, a person acts differently, does not care about the repercussions, which essentially is not his fault. Maybe it will be his fault. That will be discussed later on when we are discussing intoxication. Then comes consent. This is a very and there is a very famous example that is given while explaining this part of general exceptions, which is boxing. If someone hurts you, if it is not voluntary, then it is punishable. But if someone hurts you physically and you have consented to it, then it becomes complicated, and it requires judicial discretion, and it requires general exceptions and one's understanding of general exceptions for a determination to be made about whether or not that act is punishable. Then comes communication. There are certain things that a person in a position of authority might tell some other person that might cause that other person distress. But then, is that the someone's fault that he, say a doctor or a lawyer or a judge, is saying something to somebody that might cause that somebody distress, but it is not his fault that somebody is suffering distress because of the honest communication. And what constitutes an honest communication is also what we will be getting into while discussing that general exception. Next comes duress. Duress is legal parlance for forcefully or intimidating somebody to get something done by that somebody. Maybe you have a gun to your head, maybe you are maybe you have been rendered incapable of saying no to a person, and under those circumstances, where if you have committed certain acts that can be called crimes, you know what you are doing. There is actus reus, there is mens rea, but is it your own thoughts that you were following, or is it someone else's thought that you were following because you had no other choice? These aspects will be dealt with when we discuss duress. Next come trifles. Trifles are things that bear no consequence, things that happen accidentally, that usually have not much consequence, and those things will be discussed in trifles. The next come the private defense. When we discuss private defense, it encompasses some 10 sections, section 34 to 44 of BNS. Private defense is all about retaliation. Private defense is all about whether or not you perceive some danger from some person or some circumstance or some situation, and you act in order to save yourself or somebody else or your own property or your own body or anything of that sort, then that you do to protect yourself from imminent danger. All of those things are discussed in the sections that encompass private defense. Now, before we get into the sections themselves, we will have to discuss certain things called I've been told that actus reus and mens rea have already been covered, so I'll keep that discussion very brief. But I will get into this one thing, saying ignorance of fact and ignorance of law. We were discussing mistake, and we were discussing an incorrect understanding or belief about something, and that incorrect understanding and belief is a result of ignorance. Now, ignorance with regards to what? There is two kinds of ignorance in legal parlance that are discussed usually. One is ignorance of fact and the other is ignorance of law. And there are two Latin maxims that govern the interpretation of the ignorance and whether or not it can be excused. Number one is ignorantia facti excusat, meaning ignorance of fact can be excused. There is another one, ignorantia juris non excusat, which means ignorance of law cannot be excused. Usually when someone says or someone breaks the law, then that someone cannot go back and say, no, I had no idea that this law existed, therefore I was only acting ignorantly, kindly excuse this action of mine. That action cannot be excused. But if that someone was ignorant of a particular fact, not law, he was ignorant of a particular fact. Say for example, he was ignorant of the fact that the wall was rickety and he put weight on it, and that wall kind of ended up injuring a certain other someone who was standing on the other side of the wall. That is ignorance of fact. A person cannot be expected to know anything and everything at any certain point of time. Therefore, that ignorance of fact can be excused. This is a legal concept and legal terminology. Ignorantia facti excusat. Ignorance of fact can be excused. Ignorance of law cannot be excused. Ignorantia juris non excusat. This is one concept that needs to be understood by the participants before we move further. There is another concept that needs to be understood by the participants, which is actus reus and mens rea. In the substantial law in BNS, the concept of actus reus meaning the act itself, and mens rea the intention behind the act. When a crime is said to be committed, both these things should exist. Actus reus should also exist, meaning the act itself had to have been committed, and mens rea should also exist, meaning the intention behind the act should also be there whilst the act is being committed. Now comes the first general exception. section 14 of BNS. Act done by a person bound or by mistake of fact believing himself to be bound by law. Nothing is an offence which is done by a person who is or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. That's a lot of words strewn in together. As I was discussing, the legal parlance usually is the section is not written for easy understanding. The purpose of writing that section is to prevent loopholes to be exploited. What it essentially says, what this section essentially says, is that genuine belief due to a mistake of fact is not an offence. If a person genuinely believes that he is bound to do something and he does it with no malicious intention, he is just thinking that he is bound by law to do it, therefore he does it. Now if that thing ends up hurting somebody, if that thing ends up becoming a quote unquote offense according to the act, because it kind of checks all of the essentials, even then that act done by that person can be excused according to the general exceptions. A couple of examples have also been given. One is a soldier fires on a mob by the order of his superior officer in conformity with the commands of law. If that firing has resulted in somebody getting injured, or if that firing has resulted in somebody getting killed, even then a soldier acting under orders has committed no crime. Or for example, say a police person, after due inquiry, after a warrant, after he receives a warrant, after a warrant is issued against, say, an ex person, he goes to the residence of the ex person, he kind of does all of the inquiry that needs to be done and comes to the conclusion genuinely that this person who is residing, who is in front of him, is X. And he finds out later on, after X has been arrested, that the person that he has arrested is not that person at all. That is illegal arrest. But then that kind of checks all of the boxes of illegal arrest. The person that you have arrested, that you have been issued a warrant to arrest, is not the person that you have arrested. That is textbook illegal arrest. But then he has committed no such offence under the general exceptions if he can prove. The onus of proof here is different. Usually what happens in law is that the accused can only create reasonable doubt. He can only say, no, I have not been there. He can only deny. And the onus of proof is on the prosecution. Usually this happens in BNC, in the law, that the accused has no onus of proof on him. He can just deny. But the prosecution has got an onus of proof, meaning the responsibility to prove that the accused has in fact committed the crime. But in general exceptions, whoever wants to invoke general exceptions, that person is the one that the onus of proof is on, meaning the responsibility to prove that you fall under the general exceptions is your own, because you have chosen to invoke general exceptions in the first place. Therefore, in the example, if that officer can prove that he has made all sorts of inquiries, say he can prove, for example, X was the twin brother of Y, therefore he got confused and he arrested Y. Nobody told him during the inquiry that Y is X's twin brother and he was residing at X's residence, at which point the police officer arrested him. A lot of things practically might happen, and if the police officer can prove that he made no mistake with respect to executing that warrant, at least in his own mind, then he is eligible to invoke general exceptions. Once again, this invocation of general exception is subject to judicial scrutiny and is also subject to judicial discretion. A judge, a presiding judge, might make a decision based upon the circumstances of the case, the situation at that point of time, and the proceedings in the court and the evidence before him. All of these things the judge will take into consideration before allowing a general exception to be invoked or not. Then comes section 15, act of judge when acting judicially. Nothing is an offence which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Say for example, there is a defect in the judgment or in the orders pronounced by the judge, which kind of becomes an illegality in itself. Maybe a wrongful conviction happens. You have by the virtue of the wrongful conviction deprived a citizen of his fundamental right. That itself is an act that checks out some essentials of a crime. But do you prosecute the judge? Not if he has done his job believing and judiciously acting and in good faith acting like a judge and acting judiciously and performing the act in good faith. If the judge makes a decision and even if that decision is quote unquote wrong, even then the judge will not be the judge is excused essentially. And section 15 and section 16 are usually read together. Section 15 is about the judges who are acting judiciously. Section 16 is about the people who act on the basis of the judgment that has been pronounced by the judge, the orders that have been pronounced by the judge. Now, some of the essentials of this are: number one, the judge must be acting judiciously. Number two, the act must be within jurisdiction. Ultra virus meaning beyond the authority acts, do not fall under this section. And the act must be performed in good faith. If there is proof that the judge has not been acting in good faith, then this section does not get invoked. Then come the people who act on the basis of the judgment. Section 16, act done pursuant to judgment or order of court. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court, if done whilst such judgment or order remains in force, is an offence, notwithstanding the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. When we were discussing the essentials, number 2 was act must be within jurisdiction. Now the judge would have the idea of whether or not he has jurisdiction, but the person who is acting out the order, his circumstances may prevent him from having the idea of whether or not that falls within that judge's jurisdiction. Maybe he in good faith must have thought that a particular area fell under the jurisdiction of that particular judge upon whose orders he was acting. In good faith, if he does believe so, and if he does have the opportunity to prove the fact that he was acting under good faith, then the section 16 may be invoked. Now section 17, mistaken belief of justification. This is kind of an offshoot of the previous section. Acts done in good faith under mistaken legal justification are excusable. The example is if a police officer has seen a cognizable offence, quote unquote a cognizable offence, where one man is beating up another man quite severely with a weapon. Now he under good faith will think that yes, this is a cognizable offense, this checks all of the essentials of a cognizable offense, therefore I can act without a warrant, and he goes and arrests the person who was doing the attacking. Later on it gets proved that the person who was doing the attacking had not attacked first. In fact, the weapon that this person had on him was the weapon that the other person had brought to attack this person, and this person was able to effectively defend himself. And all of this was happening before the police person arrived at the scene of offense. And after that police person had arrived, all he has seen was the person defending himself against the attacker, and he mistakenly thought that the person who was attacking, who was defending himself, was in fact the attacker, and then he arrested that person. Now, is this act, essentially this act checks all of the essentials of an illegal arrest once again, but then the police officer, if he can prove the fact that it was only a mistake of fact, and that he genuinely believed that the other person was the victim, and the person that was doing the hitting was the perpetrator, and if he can prove the fact that he was acting in good faith, and if he was acting under the mistaken belief of justification, if he was acting under the belief that he was legally justified for what he was doing at that point of time, if that can be proven, then this section can be invoked. Act done by a person justified or by mistake of fact believing himself justified by law. Nothing is an offense which is done by any person who is justified by law, or who is by reason of a mistake of fact and not by reason of mistake of law in good faith. The emphasis should be given to the fact that this section can only be invoked in case of a mistake of fact and not in case of a mistake of law. In good faith believes himself to be justified by law in doing it. A sees Z commit what appears to A to be a murder. A, in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murderers in fact, seizes Z, and in order to bring Z before proper authorities, A has committed no offense, though it may turn out that Z was acting in self-defense. That is the exact example that we had used. Then comes accidents. Usually things that happen sometimes are out of our control despite our best efforts. This is precisely why this section gets invoked, saying that any lawful act done in a lawful manner by lawful means with proper care and caution and all of the precautions taken, despite all of that, sometimes accidents might happen. Now, is there actus reus? Yes. Is there mens rea? Not really, because all of the precautions have been taken for the act not to happen, but despite the best efforts of that somebody who was taking precautions, this something happens which is termed as an accident. And if it can be proven that that somebody was taking all of the necessary precautions, that somebody can invoke this section. Accidental acts during lawful activities. Accidents occurring while performing lawful activities with caution are excusable. Say for example, a carpenter or somebody who is in charge of using heavy machinery, maybe somebody who is drilling a road, he has done all of the checks and balances before using that machine. Maybe the drill bit pops off and injures some other person who is walking on that road due to happenstance or just sheer coincidence. This person is drilling the road and the drill bit just flies off in the face of that person and fatally injures him. Now, if this person can prove, if the operator can prove that he has taken all of the necessary precautions, he has followed all of the things that he has to follow, all of the checks and balances have been duly taken into consideration, and before he uses the machine, he checks it every time, and if he can prove, if there is a lot of documentation that is required that he has to sign off on, if he can prove that he has done all of the things that are necessary, if he can prove that he has taken all of the necessary precautions before operating the drill bit, then his action of injuring the passerby on the road may be excused. This is accidental acts during lawful activities. Nothing is an offence which is done by accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means with proper care and caution. The example is A is at work with a hatchet. A hatchet is something that you chop trees with. And the head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Meaning, if he has taken all of the proper precautions that he is supposed to take, then the head of the hatchet flying off and killing a man is not an offense according to this section, when this section is invoked, and the onus of proof of having taken all of the necessary precautions will fall upon the person who was handling the hatchet, who was working with the hatchet. Now comes section 19. Some harm is done to prevent a greater harm. A typical example is given during a lot of IQ tests that has been taken from this. Say there is two routes, a bus driver who is not able to control the bus takes a route that has got minimum pedestrians instead of the route that has got houses, thereby injuring some pedestrians but also saving all of the people in those houses and saving all of the passengers in the bus. But he has willfully injured some pedestrians by taking willful action. There is actus reus, there is mens rea. He intended to take that route where some pedestrians were on the street, but if he can prove that he did it to save more lives, to save all of the lives of the people that were residing in those homes, and to save all of those people who were riding in the bus that he was driving, and if he can also prove that he has taken all of the necessary precautions and the fault of the bus not being able to slow down is not his fault, then this section can be invoked. Some harm is okay if it is done to prevent a greater harm, which has been taken from a Latin phrase, a Latin concept called jus necessitatis, which means the doctrine of necessity. Jus necessitatis says that necessitas non habet legem. Necessitas non habet legem, which means necessity has got no law. Necessity has got no law, which means if there is enough necessity and if there is really no choice between, if there is no option C, if there is only a choice between choosing option A and B, if that person making the choice in his right mind while considering everything and after having taken all of the necessary precautions chooses the option that does less damage, does damage but lesser damage than the other option, if he chooses this option and does that damage, then this section may be invoked. Jus necessitatis may be invoked, and there is a very famous and a very old case law with regards to this. We shan't go into the details of that case law, but then before going into the case law, there is something called Regina and Rex. In Latin, regina means queen and rex means king. So R versus Dudley is the case, Regina versus Dudley. What happened was four sailors who were on a voyage, they get lost because their ship gets wrecked in the middle of the ocean. They manage to escape with a dinghy, which is a small boat. There is four of them, including a cabin boy, three fully grown men and one 18-year-old boy. And after having survived for a very long time, they make the drastic decision of killing that boy and eating him. Now this is the origin case. This is where in common law jus necessitatis has gotten its place officially right after this case. Those sailors were not forgiven, but then they pleaded the doctrine of necessity, and they tried to save themselves from sentencing, saying that it was a necessity of whether one person should die or the rest of them should survive. And out of the three, only two people do this act and say that two lives have been saved by killing one person. Therefore, the doctrine of necessity, jus necessitatis, can be invoked for us to plead defense. The goings on of the case we will discuss later on, but then this is a very famous case and it has to be mentioned, and it is mentioned time and again. R versus Dudley, Regina versus Dudley. Dudley was the prime accused, was one of the sailors who apparently came up with the decision to kill off one of his mates and eat him. Yes, they were punished. Yes. Yes. Moving on, they were punished. But then through this case, jus necessitatis got a lot of traction with respect to common law. Yes. Right. Now comes infancy. As we were discussing earlier, certain things can only be understood as a person ages, because there is certain things that only a mature mind can understand and can adapt to, and a certain level of IQ is gained as a person ages. Now, before that person reaches that certain age, that person may lack the capacity to understand the consequences of an action, when to do certain acts, why to do certain acts, why to refrain from doing certain acts. All of these things can be understood as a person ages, and without that age to understand, to decipher right from wrong, without having that age, that person, if he does a certain act which can be called a crime, essentially actus reus and mens rea both exist, but then that person can be excused because that person lacks the mental capacity owing to his age. Now there is two sections here. The age has been divided. Section 20 says any act or nothing is an offense which is done by a child under 7 years of age. The first cutoff is 7 years. So if a child of 6 years, say, unintentionally pours nail polish remover inside of a drink that an uncle that he does not like is drinking, and that uncle drinks that and dies, is it the child's fault? The child intentionally wanted, he did not know the meaning of the word poison, he did not know the repercussions of pouring the nail polish remover in the drink. So is it his fault? If he is under the age of 7, no. This act says if the child is under the age of 7 and if he inadvertently or even knowingly sometimes does something that results in injury, then it is not his fault and he can be excused. Section 21 elaborates it a little further and takes it a little further, saying any child above 7 and under 12, if he does something inadvertently, depending upon what he did and whether or not he has got an understanding about what he did, this section may or may not be invoked. It says act of a child above 7 and under 12 years of age of immature understanding. The emphasis here is on the level of understanding and the immaturity behind the act. If it cannot be proven, or if it is somehow proven that the child of above 7 and under 12 was having an idea about what he was doing at that point of time, then this section cannot be invoked. It all depends upon whether or not it is proven that that child was having a mature understanding or not. Nothing is an offence which is done by a child above 7 years of age and under 12 years of age who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Children under 7 are incapable of committing a crime. Those between 7 and 12 are liable only if they understand the fact that they have committed a crime. Next comes insanity. The plea of insanity is pretty famous among the general exceptions. Acts by the mentally unsound. The mentally incapable individuals are not criminally responsible for their actions because maybe actus reus exists, but mens rea is a little iffy when it comes to judging a person who doesn't really understand right from wrong, whose mental incapacity or whose condition incapacitates him mentally from understanding the consequences of his actions. If it can be proven that the mental capacity of that person prevents him, or the mental capacity of that person is inadequate, then the the plea of insanity may be entered into and that section may be invoked. The act must be done by the person of sound mind. These are some of the essentials of the invocation of section 22. The act must be done by a person of unsound mind. It has to be proven while invoking this section, as we were discussing. While invoking general exceptions, the onus of proof is on, the burden of proof is on the person who is invoking the general exception. So it has to be proven that the act has been done by a person of unsound mind, and such person must be incapable of knowing the nature of the act. He should have no idea what he is doing. Incapacity should exist at the time of doing the act. Sometimes the mental capacity comes and goes. While doing the act, if that person had an idea about what he was doing, even if he has temporary bouts of insanity afterwards, he can be punished, because when he was doing the act he had sufficient mental capacity to decipher right from wrong. Therefore the incapacity, it is one of the essentials that the incapacity should exist at the time of doing the act. Now there is a couple of tests: wild beast test and McNaughton's test. The McNaughton's test is also a result of a case which happened in 1843 during the trial of a Mr. Daniel McNaughton, who suffered from delusions. And one fine night one night he shot and killed a Mr. Edward Drummond, thinking that he was the devil incarnate, thinking that he was a demon. This person, McNaughton, had shot Mr. Edward Drummond and killed him. It was then that the McNaughton's rules had become a legal standard for insanity. There are in essence two rules. There are many guidelines that were given, but two of the most important rules is: number one, he did not understand the nature and quality of his act. While doing the act, if it can be proven that he did not understand what he was doing, the nature and the quality of his act, he was thinking, he was under the impression that he was attacking the devil, but it was some other person that he was shooting at, and he did not understand the nature of what he was doing. And number two, he did not know the act was wrong. Number two is that when he was shooting at a demon, he thought, he actually was under the impression, because of his delusional mentality, he thought that he was actually doing a good thing. Shooting at a bad thing is good. That was what he was under the impression of. That is the McNaughton's rule. Now the wild beast test. Some of the nomenclature here is rough and might hurt the sentiments of the modern human with a modern mentality, but then we should take into consideration the fact that these were very old rules that were written, and we are still mentioning those rules, because those rules are essentially origins of the rules that have been written now. The wild beast test is an early kind of English common law test that was used to determine criminal insanity. And the wild beast test says, and this is only for academic purposes that the wild beast test is mentioned. There is no such thing that happens now. There is a lot of nuance with respect to testing the mental incapability or the capability of a person now. And the wild beast test said that if a person has lost so much control of reason that they were akin to a wild beast, then the plea of insanity may be entered into. These two are things that are usually mentioned as origins: the McNaughton's rules and the wild beast test. If a person is capable, or if the counsel of that person is capable of proving the insanity or the lack of mental capacity of a person while that person was doing a certain act that can be considered an offense with regards to the substantial law, then if it can be proven, then this section may be invoked. Section 22, insanity and unsound mind. Next comes intoxication. Insanity is one thing and intoxication is another thing. Intoxication has been divided into two categories: voluntary intoxication and involuntary intoxication. Usually involuntary intoxication is what is given a leeway with respect to saying that acts committed under involuntary intoxication are not criminal offenses. Maybe a person was drugged against that person's will. Maybe that person did not know that what he was drinking was alcohol. He was under the impression that he was drinking a non-alcoholic drink, and maybe he was drugged, and under the influence of that drug or under the influence of that alcohol, he has committed something akin to an offense. And if it can be proven that he did not voluntarily ingest himself with that substance that has impaired his mental ability, if it can be proven beyond reasonable doubt, then this section may be invoked: involuntary intoxication. The section reads thus: the act of a person incapable of judgment by reason of intoxication caused against his will. The imperative part of this heading is causing intoxication against his will. Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. He needs to be incapable of understanding that what he is doing while he is intoxicated is against the law. if it can be proven that even when he was intoxicated he had the understanding of whether or not what he was doing was correct, then we have a problem. Otherwise, if it can be proven beyond reasonable doubt that he did not know what he was doing and he did not know that it was contrary to the law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Number one, he should have no idea that a drug was being administered to him to make him feel intoxicated, to reduce his mental capacity. That's number one. Number two, he had an idea, but he was opposed to the idea and he did whatever he could to not be drugged. The thing that which intoxicated him was administered to him without his knowledge or against his will. These are the imperative points that need to be proven beyond reasonable doubt. He should prove three things. Number one, he was intoxicated involuntarily. Number two, it was administered to him against his will. Number three, he did what he did without having any idea that the thing that he was doing was against the law. These three are the things that are imperative things that need to be proven beyond reasonable doubt in order to invoke this section. Then comes the next section, offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. One of the imperative points that needed to be proven, as we have already been discussing, is the fact that he should not have any idea that the thing that he is doing while he is intoxicated is against the law, or the thing that he is doing is wrong. His lack of knowledge should also be proven. And if his lack of knowledge is not proven, then he cannot invoke the intoxication plea. And if he voluntarily got himself intoxicated, if he had a couple of drinks voluntarily, and if he had administered the drug voluntarily, then he cannot invoke this section. Then comes consent. There is a lot of interpretations to the meaning of consent. There is another section in the general exceptions itself that gets into what is consent and what is not consent. And there is a lot of Latin maxims such as volenti non fit injuria and some other Latin maxims that we will get into shortly. Anything that has been done with the consent of the opposing party, if it is an injury, volenti non fit injuria meaning if you voluntarily invite injury, then it is not an injury. The popular example that is given is, say there is a sparring bout between two trained fighters. It is just a sparring bout and one of the fighters has punched the other fighters, and that punch has proven to be fatal. Now the one who was doing the punching, he was fully aware of what his punch would do, and he was fully aware of the effect and the circumstance and everything. But the fact that the other fighter voluntarily had stepped into the ring with this person, and that the other fighter knew fully well the consequences of taking a punch in his face, changes everything, and this section may then be invoked. Volenti non fit injuria may be invoked. Section 25 reads thusly: act not intended and not known to be likely to cause death or grievous hurt, done by consent, Nothing which is not intended to cause death or grievous hurt. The boxer who is doing the punching, he is not punching because he wants to kill the other person. It was just a bout. He was just trying to win the sparring match. So the intention behind the punch is what is important. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt. This boxer had no idea that that boxer would die from one punch. Nothing is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent. Because consent, there is a lot of things that have to be taken into consideration for a consent to mean legal consent, and one of the things that is taken into consideration is the fact that the person who is giving consent is not a minor but a major. Statutory rape and everything we will cover in the sessions that follow. A person above 18 years of age who has given consent, whether express or implied, to suffer that harm by reason of any harm which it may be known by the doer to be likely to cause such person who has consented to take the risk of that harm. Consent can be expressly given or impliedly given. The illustration that has been given in the act is that of a fencing bout. A and Z agree to fence with each other. Fencing is with rapiers. Rapier is a kind of sword. Agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing, because if you get into a boxing match, you will any person with the same mind who applies his mind will know that a boxing match entails you punching the other person and the other person punching you. So to suffer harm which in the course of such fencing may be caused without foul play, and if A while playing fairly hurts Z, A commits no offense. No offense has been committed by A if the consent that has been if there is consent that has been given by Z, either explicit or implied. Then after this follow sections that exculpate doctors usually. An act done for another's benefit in good faith. Acts done in good faith for someone's benefit with their consent or the guardian's consent are not offenses. Say for example, a doctor performs a risky eye surgery on a child with the guardian's permission, or a doctor performs a brain surgery with an apparently mentally unsound person with the permission of once again the guardian. If that surgery is not a success and if the patient dies in the process, the doctor can invoke this general exception, because all of these things have been put into place to take away that sense of fear from either the person acting in good faith or the judiciary or the medical officers, the doctors and everybody. If there is a sense of fear with respect to doing their jobs, the effectiveness might go down. Therefore some of these sections have been put into place to prevent unnecessary litigation with respect to doctors and judges. This section reads thusly: act not intended to cause death done by consent in good faith for a person's benefit. Nothing which is not intended to cause death is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith and who has given consent, whether express or implied, to suffer that harm or to take the risk of that harm. The imperative portion is number 1, good faith, number 2, consent, and number 3, the knowledge of the risk. The knowledge has to be possessed by either the person saying yes to receiving or either saying yes to the risk of harm, or by the guardian of a person that is going to be harmed. The consent should be there, good faith by the doer of the act should be there, consent whether express or implied should be there, and the knowledge of the risk should also exist. The illustration reads thusly: a surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under painful complaint, vagera vagera. This is the exact example that we had used. Then comes section 27, which says that a child or somebody of unsound mind, the consent has to be given by the guardian. This we have already discussed. Number one, the act has to be done in good faith. Number two, if there is a person under 12 years of age, or if there is a person under unsound who is of unsound mind, the consent has to be given by the guardian of that person, provided that this exception shall not extend to the intentional causing of death or attempting to cause death, because then that action is not done in good faith. This action has been done in bad faith. Therefore, the intentional causing of death or attempting to cause death will render the invocation invalid. The doing of anything which the person doing it knows likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. Say there is a clot in the brain, the incision has to be made and the brain has to be accessed through the skull. Now, if the clot does not exist and if the incision is made unnecessarily with malice, or while acting under bad faith, then this invocation of this section becomes invalid. Voluntarily causing of grievous hurt or to attempt to cause grievous hurt, unless it be for the purpose of preventing death or grievous hurt, for the curing of any grievous disease or infirmity, or abatement of any offence, to the committing of which offence it would not extend. Abatement is a concept that comes in chapter 4. We are currently in chapter 3. We will discuss abatement when we get there. Then comes the definition of consent. What is consent and what is not consent? Section 28 gets into the manner in which a consent is supposed to be taken, and whether or not the consent that is given is genuine or not, valid and invalid consent. Consent given under fear, misconception, or by somebody who is incapable meaning insane, underage, intoxicated, etc. Consent given under fear, misconception. If consent is given under duress, gun to your head, you will consent to anything. That is not proper consent. A minor who does not have the mental capacity to decipher right from wrong, statutory rape comes under this. We will get into it when we at a later point of time. Consent given under fear, misconception, or by someone incapable of giving that consent is invalid. Now comes section 29. Some acts remain crimes even if they are done after getting consent, a valid consent, mind you. Some acts like causing a miscarriage remains a crime despite the plea of consent. A doctor who has done an illegal medical procedure like causing a miscarriage, even with the consent of the mother who was carrying and the father or the husband of that mother, even if the consent was genuine, even if that consent was not given under fear or misconception, everybody knew what they were doing, even then, that despite having consent, there are some acts which are still crimes. Then come acts, emergency acts that are done without consent because of the time factor. Some things need to be done, like life-saving surgery. There are some decisions that a doctor needs to take during a medical procedure that he cannot wait for the consent of. Say reviving an unconscious patient might require him to beat a patient's chest or to cause some other sort of hurt on that patient's. patient and he does not have time to ask for consent or get consent from either the patient or from the guardian or anybody. Despite knowing all of this, if he acts in an emergency situation in good faith, these acts are excusable. And then comes good faith communication. Say if a judge or a doctor gives some sort of information, so gives some sort of communication to a particular person, and that particular person suffers mental trauma after hearing that piece of communication. Now, is it the fault of the person who is giving that statement? Not really, because the mens rea is not there and that person was not intending for any harm to befall the person who is listening to the communication. Therefore, section 31 states good faith communication can be excused even if harm is caused due to that good faith communication. Then comes acts done gun to your head, as they say, under immediate threat of death. But there is a limitation to this section. The acts cannot be grievous offenses. But apart from murder and other grievous offenses, if acts that are committed under threat of immediate death, except serious crimes, are excusable. Say a person has a gun to your head and says you have to steal a certain article from somewhere. If you do it, you are doing it with a complete idea of the consequences of your action, because you are sane and there is mens rea, there is actus reus, there is everything that checks all of the essentials of the crime, but you had no choice in the matter because you were threatened with immediate death. Your action, if you can prove that you were under the gun and were threatened with immediate death, if it is if it is proven in the honorable court, then this section can be invoked. Then comes section 33, trivial harm. Say a slight bump in a crowded area. If someone says इसने मुझे कोनी मार दिया, कहाँ पे, दिन दहाड़े बस के अंदर बहुत सारे लोग देख रहे थे, in front of witnesses, इसने मुझे कोनी मार दिया. Then later on you found out that the person who did the elbowing did not really want to do the elbowing, he was just jostling for some space. That is not an offense with respect to this section. If it is proven that a slight bump in a crowded area or a minor harm, the harm is minor, if that can be proven, this section can be invoked. Next comes right of private defense, section 34 to 44. This essentially is the right to defend oneself and others, one's property, either movable or immovable. It is essentially a default protection that is given under law against theft, robbery, mischief, criminal trespass, all of these things that involve somebody posing a physical threat to you or your property or your loved ones. This is an essential default right of private defense that is given under the substantial law. The scope of the defense is given from section 34 to 35. The restrictions on the right are given in section 37. Restrictions are kind of interesting because we will get into it. Defenses leading to death have been discussed in section 38 and 41. Section 34 is acts done in private defense. An act is not considered an offense if it is done in the exercise of the right of private defense. This is essentially so that the individuals that are subjected to this law can have a means to protect themselves and others around them. Defense of body and property. Every individual has got the right to defend their own body and the body of others from offenses that affect the human body. that can be stabbing, hurting in some other manner. Their property, whether it is movable or immovable, or someone else's property from acts like robbery, theft. Say if during Diwali somebody actually has possession of actual bombs and he wants to put those bombs in your house and blast them for fun. That comes under mischief. Or criminal trespass. Somebody who does not belong on your property has, with intention, according to you at least, he has got the intention of criminal trespass. We will get into what constitutes criminal trespass. This is a section that gives you defense against all of these things, against any trespass against your property or your body. Defense against acts of intoxication or unsound mind. Granted, the general exception of unsound mind exists. Anybody who is not of sound mind during the act is not subjected to punishment under the general exception, but that does not mean you cannot defend yourself against a person who of unsound mind when he is attacking you. If a person of unsound mind is attacking you, this section gives you a right to defend yourself and to use the exact amount of force that he is about to use on him. Meaning, if an unsound mind person threatens to kill you, or at least you are under the impression that the person of unsound mind, say he has got a knife with him, this section gives you authority to grab that knife from him and stab him as a manner of protecting yourself or your loved ones. Now, when I say you can take that knife from him and stab him, then come the restrictions on the private defense. Restrictions meaning there is two kinds of restrictions. We will discuss number 2 first because it falls under this category. The harm caused in defense should not exceed what is necessary for protection. If someone wants to hurt you with a stick, you should also hurt him with a stick. If an unsound mind person is running towards you with a stick, if I take out my revolver or my Beretta, if I shoot him in the head, then this section might not be imposed because that is not private defense. I have used unnecessary lethal force that was not necessary for me to effectively defend myself. I could have even pointed the gun in the air and shot for there to be clear communication between me and the person who is trying to attack me. But instead I chose to shoot him in the head. Therefore, the harm caused in defense should not exceed what is necessary for protection. And then comes no defensive acts should be against public servants who are doing their job in good faith. Say a police person is trying to refrain or to restrict you from doing certain act, or he is trying to arrest you. You cannot invoke the right of private defense and say that police person has trespassed into my property, therefore I will protect my property and myself from that police person. That cannot happen because that is not a right that is given under this section. Defense that is leading to death. A person can voluntarily cause death in self-defense if A. the assault reasonably causes fear of death or grievous hurt. Let's go back to the unsound mind example. If a person is walking towards me and if he has a gun in his hand, if I also have a gun in my hand, I can use that gun to shoot him because the fact that the other person who is coming at me with a gun in his hand means that I am now in a position to fear for my life, and it is a valid fear because I have seen the gun in his hand and my fear is justified. Number 2, the assaulter intends to commit rape or to satisfy his unnatural lust, or he is willing to kidnap or to wrongfully confine you. These are all extreme scenarios, and human instinct of survival kicks in, and sometimes we do understand the intention behind that someone who is coming towards us or towards the loved ones. And this section gives us at least a theoretical sort of a defense against prosecution in case any act that causes grievous hurt or death occurs or is done. Then comes section 39, defenses causing harm other than death. anything that does not fall under the things that have been listed in section 38 do not warrant death. Meaning, no rape, no unnatural lust, no kidnapping, no wrongful confinement. If he just wants to hit you, you are not given the authority to defend yourself with lethal force. If the offense does not fall under the severe categories mentioned in section 38, one may still cause harm to the attacker but not death. If death occurs, then this section may not be the general that act may not fall under the general exceptions. When right begins and ends, you see, if a person at night has trespassed in your property and has ransacked your place and you were there, you couldn't do anything. You find the same exact person outside the next day, then you attack that person. Then you cannot say, because that person last night tried to attack me in my own home, therefore I am attacking him in the morning the next day. That does not happen. Housebreaking at night has to be dealt with at night, when you are fearing for your life, and while that act is being done, while the robbery is commencing, while the theft or trespass is commencing, only during that time your right kicks in. Your right to defend yourself or your property or your loved ones, that only kicks in while the act is in place. You cannot wait until after everything is done, and you cannot wait till the next morning or after the incident has happened. You cannot do something and then say what I have done falls under general exceptions. That does not happen. A person can voluntarily cause death while defending in case of robbery, housebreaking at night, but only during the duration of the act does the right of defense apply. Defense against deadly assault with risk to innocent persons. Last section 44. What if there is bystanders? If a person has trespassed into your property, or if an unsound mind person is running towards you with a stick in his hand, and you also happen to have a stick in your hand, if you want to throw that stick at him, or if you want to throw a rock at him, and if someone else is there around you, innocent bystanders are there around you, if you miss, if you have thrown the stick and that stick hits someone else, what you did is essentially, with mens rea, the actus reus you have done. You know the consequence of that stick hitting that someone. Despite knowing that fact, you have thrown that stick that has now hurt someone else. But if you can prove the fact that you were only trying to defend yourself from an attacker who also had a stick, and you have genuinely used the appropriate amount of force, but it is an unfortunate incident that someone else, the innocent bystander, ended up getting hurt instead of the person that you were trying to defend yourself against. This is section 44, defense against deadly assault with risk to innocent persons. The illustration that is given is, if a mob attacks someone and they cannot defend themselves without risking harm to nearby children, they can act in self-defense even if it results in harm to the children. We have taken more time, and also I have been told that 3 weeks is the time that was officially. It was 4 weeks. Therefore, I have requested the OSD to give me 4 weeks instead of 3 weeks, and also I have been told to take to finish the syllabus in time. Therefore, the sessions may be longer than 1 hour from now on. Usually it was 45 minutes to 1 hour, but then in order for us to effectively cover whatever it is supposed to be covered, the sessions from now onwards will be slightly longer than 1 hour. I have been told to officially mention this to the participants. Therefore, I am. From now on, we will be discussing acts. BNS, we will start with BNS, and we have started with the general exceptions. I will give a brief recap in the next session. I will also try and summarize and share the PPT with the group and the reading material with the group. The reading material will also contain the concepts behind the general exceptions, the Latin phrases and the case laws as well. So that has been general exceptions. Thank you very much.
Hey, Sally.
Good.